take it to the extreme that they truly will not respond at all, the case is ultimately going to get dismissed.
Let's say you've been in a crash and are now on the long road to recovery. You're doing your physical therapy, you're seeing the appointed doctors, and you're following their recommendations. At this point, you've even called our law firm because you know the insurance company isn't going to give you a fair settlement. Many believe that once they've signed on with a law firm, their job is done. But in reality, the journey has just begun. You may think the moment you sign a contract with us, you can wait till we come back with a pile of money for you. But unfortunately, that's not how lawsuits work. So, Pete, let's start with the first thing we need from the clients. Initial disclosures. What are they? Why are they critical?
Initial disclosures are certain information that has to be exchanged in every case within 30 days of the time the insurance company lawyer files an answer to the lawsuit. So basically, the client's obligation starts immediately, and the way we do it is we won't file a lawsuit until the client gives us the initial disclosures because, believe it or not, some clients don't do things on a timely basis. And we don't want to start off a lawsuit by having to beg the insurance lawyer for favors on extensions of time. We wait until the client has completed this document, then we file the case. This way we're in charge of the timeline.
Now, once we have these initial disclosures in, let's move on to the next step that tends to happen. We get the trial set up for the discovery plan, and we have deadlines. Once the deadlines start, a process known as discovery kicks in, if I'm not mistaken. And what does that entail for the client typically?
Well, the initial disclosures are actually the start of discovery. It's just a mandatory part of discovery that you have to provide information without the other lawyer asking. But once you get past that, now the other lawyer gets to send us written questions, asking for certain information, as well as a list of documents they want us to provide. Some of this we can do ourselves, but a lot of it requires input from our clients. So it requires ongoing cooperation from the clients, and it requires ongoing timely cooperation because when the other lawyer sends us these types of documents, asking questions and asking for documents, we have 30 days to respond.
And what happens if we miss that deadline?
Then we have to start begging. Seriously, I haven't met an insurance lawyer who will not give an extension. But the bottom line is, once you have to start asking for extensions, now you've lost your ability to push the case. So it's important for our clients to get us this information promptly. When we send it to our clients, we expect to get it back relatively quickly. I mean, a week would be plenty of time for most of this type of stuff, and it allows us to stay on track on the timeline. But unfortunately, it doesn't always work that way, and we end up more often than we'd like to having to ask favors of the insurance lawyers for more time to get things done.
And we've had clients in the past that have hit us up after we've sent them the discovery that they need to answer, and they've said,
well, I don't think this is relevant. I don't think this is something I should have to answer.
What's the standard of evidence when you're getting into the discovery process?
Well, first of all, if I represent somebody and I send them something and I say answer it, I've already made the determination. You need to answer it. But the bottom line is the standard in discovery is way broader than relevance. I mean, at trial, things have to be relevant to be brought up in front of a jury. But in discovery, I mean, the standard is, and this is lawyer mumbo jumbo, but I'm going to say it anyway, it has to be reasonably calculated to lead to the discovery of admissible evidence. That's really broad. I mean, if you think of relevance as this narrow of a standard, the one I just gave you is about like this. It's a really big funnel that all this information gets fed into, and you shake it down, and by the time it gets to the bottom in trial, yeah, it's relevance, but people have to understand, and we do our best to help them understand that it doesn't matter if it's not relevant. You have to answer the questions and the information and provide it. Trust the process. It doesn't mean because you've given a response it's going to come out in trial. It just means it's something you got to tell the other lawyer right now.
Now, when we get these discovery questions and whatnot from the opposing counsel, there's also in that 30 days a thing for objections. What are objections? How do we utilize them typically?
If the other lawyer sends a list of questions and we think that one or more of the questions would require us to provide privileged information. That's one legitimate objection to make to discovery information. And frankly, there aren't a hell of a lot more. Sometimes a lawyer will ask us for medical records for somebody's entire life.
Right.
And when that happens, we say, no, we're not going to do that. Our typical standard is, and this is supported in the rules that govern our discovery, but our typical response is, we'll give you 5 years of anything you want. And if you find something in the 5 years that makes you think there's something relevant outside of the 5 years, let us know and we'll talk about it.
Sure.
But we're not going to just give them records going back. You know, our client is 50 years old. We're not giving them records going back to birth.
Right. They don't need to know what happened when they were 12 unless it's somehow still relevant to when they're 50.
There needs to be some reasonable relationship to the lawsuit. And somebody asking for records of my birth, for example, if I was in a lawsuit, that has absolutely nothing. It's not reasonably calculated to lead to the discovery of admissible evidence. So there are some things that are so far out there that they're properly the subject of an objection. And most of the time it's because people are casting too broad of a net time-wise, asking for stuff too far back.
Let's say a client gets a hold of us, signs with us, we get through the initial disclosures, we move on to discovery, and we can't get a hold of the client. What happens if we have a non-responsive client that just isn't going to talk to us all of a sudden? We're in the middle of their lawsuit.
If you take it to the extreme that they truly will not respond at all, the case is ultimately going to get dismissed, because I told you before, when our clients don't get information back to us in a timely way, then we have to start asking for favors. So I'm going to get a hold of the insurance lawyer and say, hey man, you know, I need an extra 2 weeks. And they will uniformly say, yes.
Sure.
2 weeks go by. I need another 2 weeks.
Right.
Most of them are still going to say yes. The additional 2 weeks go by and I ask for more. More often than not, they're going to pick up the phone. Now they're going to say,
hey, Pete, what's going on here?
Right.
And at that point, I'm going to be honest. I'm going to say, I can't get a hold of my client. And the clock really starts ticking now, because you can't just indefinitely not provide information. So enough time goes by, and most lawyers are very professional about this. So once they realize that you're having a client problem, they'll give you one more chunk of time within which, if you don't provide them the information, they're going to file a motion for, it's called a motion for sanctions. And things are really going to start happening that are negative to the case. And ultimately, it's going to get dismissed if the client will not respond to us.
So there are some steps before the client not responding and the case getting dismissed, but ultimately it is going to go there if they don't take care of business that they need to take care of.
Yeah, and it's super frustrating when it happens too. So, you know, it's not okay to think,
well, I've got all these steps that are going to happen before my case gets thrown out, so I can just take my sweet time.
if you want to keep your case moving along in a timely fashion, and most people do,
Right.
then you need to do things from your end in a timely fashion.
Sure.
You know, they do things in a timely fashion. We do our job in a timely fashion. We get the case to trial when it should get to trial.
So Pete, let's say we have a settlement offer on the table and we're trying to relate to the client, but the client's not picking up the phone, not checking emails, texts, nothing. How does that work?
A settlement offer is typically good for a reasonable amount of time or until the other lawyer revokes it.
Sure.
So there's no technical time frame that you have to accept an offer within. But again, defense lawyers, if they've gone to the trouble of offering money to settle a case, they're probably going to follow up. And at some point, they're going to want to know why they're not hearing back. If you've already met all your other timelines, I mean, we've talked about the discovery timelines and how you can get thrown out of court if you don't provide discovery on a timely basis. So I'm assuming we've already met all those. There's no more discovery to be done. And now it's just a settlement offer.
Sure.
There's nothing the insurance lawyer can do to cause a problem if we don't respond to a settlement offer, other than at some point say, all right, you haven't responded, I'm taking it off the table.
So eventually the consequences, it goes away and trial begins.
Yeah, but of course, if the client hasn't responded to a settlement offer where the insurance company is offering to pay money, the chances of them showing up to communicate with us for trial probably isn't very good either.
Yeah, it's a whole different issue.
I mean, that's the whole purpose of hiring us, is to get you money to reimburse you for your damages. So if a client will not talk to you when it's time to talk about money, they're probably not going to talk to you about anything.
Fair point. This takes a while to get to trial regardless, and every extension we ask for just adds time potentially, and that's the issue here.
Yeah, I mean, when you talk about speedy justice means a different thing to most people than it does to lawyers, because lawyers know that it just takes time, and it's frustrating. I know it's frustrating for clients, because why the hell do I have to wait for 2 years to go to trial?
Right.
And there is nothing I can do about that other than file the case right away when I get it. And once I do that, my control over the timeline for getting it to trial is over.
And because this is civil and it's not criminal, we don't get the right to speedy trial scenario where we can push it real quick.
Correct.
So let's say the case is over and we either went to trial and won, or we got a damn good settlement, right? And there's just a pile of cash, but we can't get a hold of the client. What happens now?
Believe it or not, I've had that happen.
Really?
Yeah. Yeah. Talk about frustrating. I mean, ultimately, when we settle cases or get jury verdicts, the money goes into our client trust account, and we cannot just leave it there indefinitely.
Sure.
I mean, if the state auditors come around and see that there's a deposit in our client trust account that's been sitting there for quite a while, they're going to, at a minimum, slap us on the hand, and it could be worse. But ultimately, when this happened, we sought the input of the Client Security Commission, the Ethics Commission, and what we were told is, at some point you give a last notice, and if the client doesn't respond, then you just pay the money over to the Great Iowa Treasure Hunt. And and a lot of people are familiar with this, but it's basically found money. And it'll be published all over the state of Iowa in newspapers, online, all kinds of things. And maybe that way the person will eventually find their money. But at that point, it's off our hands. We've paid it into the Great Iowa Treasure Hunt. And if the client doesn't find the money, well, that's the end of it.
Fair enough. Look, we know that nobody likes hidden fees, much less hidden homework. We want you to trust us when you call, which means you'll want to know exactly what to expect when working with us. Thanks for watching, and if you found this video interesting, stick around to check out the next video on your screen now. Until next time, speak truth to power. Brought to you by the Biker Lawyers. Injured? Ride with us.